Good evening. This is Rahul Reddy. Every Tuesday, Reddy Neumann PC does bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Today, we're going to talk about the H-1B lottery. March 6th, tomorrow, is the opening day of the registration window. So we'll talk about what to expect with that and what the process will be. And then how to deal with job changes and I-140 approvals. If you're getting a promotion, how does that impact your labor certification that's already proved? Do you need to file an I-140 amendment? What steps do you need to do in that situation? And what do you do if you receive a 221G notice when you go for visa stamping? This is basically a visa rejection for additional administrative processing. They can give it for lots of different reasons, and sometimes they ask for documents, sometimes they don't. So what do you do in that situation? And we're going to talk a little bit more about the H4 EAD, what opportunities are available for people who are on H4 EAD, and what are some of the challenges that people face when they are using that work authorization.
Emily, now everything seems to be fine. Employee registration, we're going to be filing H-1Bs from tomorrow, which is March 6th. Anything that we need to report to the people? What's going on that?
So right now we're able to invite companies to create their account and connect with us in the system. When we log into the system, for those companies that have already done it, we can see them in our portal. For those that haven't done it yet, it'll say that they've been invited and when that invitation expires. In order to actually submit the registration, they have to complete that process. So we'll know tomorrow morning, well, tomorrow around noon, how it goes with the initial actual registrations. There's been glitches the first day every year, so I don't intend to work on any of mine on the opening day. I usually wait until those glitches have been worked out. It doesn't give you any advantage to get your registration submitted on the first day. Just don't wait till the very last day, because March 22nd, we only have until noon Eastern time. So definitely get the registration done by March 21st to avoid that last minute rush. But so far, the glitches that have been happening with creating the accounts and connecting with attorneys, they have been pretty responsive and helped to get those resolved.
H-1B holders, how do they handle the job changes? Typically, especially with the I-140 approvals, I want people to be very careful right now. It's taking about 2 years to get the POM approval right now. If you start from the scratch, especially for bigger companies, and some of the companies have put a hold on filing the POM application. So when you're moving on to H-1B, you need to check with your company if your new company is going to file an I-140 approval, especially if you don't already have an I-140 approval. And let's assume that your company is already going through the POM process, and this is the first I-140 that you're going through. We do not recommend people to leave the company, even if you're getting a lucrative offer with a different company, because you keep on changing like that, you will hit the 6 years. And once you hit the 6 years, you cannot extend the H-1B unless you have an I-140 approval or labor pending for more than 1 year. People may ask question, well, we'll file the labor immediately. No, you can't just file the labor certification immediately. It takes time to file the labor certification. There is something called prevailing wages that need to be applied, and it is taking approximately 8 months to get the prevailing wages from the Department of Labor. And then afterwards, there is a recruitment process. So it may take almost 1 year, depending on how the company, where the process is. Anywhere between 2 months to almost 14 months is the process to file the POM labor certification. Then afterwards, it's taking about 13 to 14 months to get the labor certification approval. So we want people to be mindful of these things, that if you're planning to change the company, though, let's say you are in this 3rd year of H-1B, you change to a new company, and the new company may not be able to file the labor certification immediately. You will hit the 6 years. So many people contact our office right at 5 years and 11 months and 10 days asking us, what's the solution? The best solution is to find the solution immediately. Don't go further. If you you're already in a 4th year right now and you have not filed the labor certification, you may be in big trouble. You may have to pack your bags and leave the country after 6 years. There are certain alternatives, though, that you may want to discuss with your immigration lawyer, but try to file the labor certification as early as possible. Changing the jobs, getting a better job may be important for you. But if you are willing to pack your bags in 6 years and leave the country, that's fine. But if you want to stay in this country beyond 6 years, you need to focus on the labor and I-140 approval. Anything else on that front, Emily?
No. So next up is 221Gs. So for people who are going for visa stamping, whether it's Dropbox or interview appointment, they go through the interview, and at the end, the officer just says, your case is in administrative processing. Here's a pink sheet or a blue sheet or a paper that tells you what happens next. So what exactly does that mean when someone gets a 221G?
That means that your case is on hold, is under investigation. Sometimes they may request additional documentation. Sometimes they may not request additional documentation, but they're doing some sort of inquiry into your company, whether it's if FDNS, fraud detection unit, may come to your end client or your employer, and or somebody from the background may check whether or not everything is genuine in the applications that you have filed. There are some cases where it's taking a long period of time. If it's taking a long period of time, we suggest that you may consider other options by taking the Department of State to the court. That's one thing that you may consider, especially if it's taking a long time to adjudicate your case. Emily, we are noticing a lot of 221Gs for the especially multiple filings and also for the in-house projects. Can you explain what these multiple filings are? What is this in-house projects we typically see, the 221Gs and the visa denials?
Yeah, so with multiple filings, this has happened over the last couple of years when an individual gets a job offer from the company they're actually working for, and then in order to increase their chances in the lottery, they find other companies to sponsor them. Sometimes they pay those other companies to sponsor, or sometimes the company that you're working for has a friend company that decides they're going to register all of the same people. So regardless of how it happens, if your name was entered multiple times by multiple companies, in a lot of cases, most of those cases, the job offers were not legitimate job offers because they didn't have actual work for you at the time they were submitting that. And so the Immigration Service is able to put all of that data together because it is an online filing system, so they can easily see. They dig into, address of the company, who registered the company. They find out it's someone else's brother's, cousin's, sister's, friend. They figure it all out. People are using the same FedEx account, sometimes the same office space. So they dig into all of that and find out that the same people colluded together to file multiple registrations in order to increase the chances. So that's one side of it. Another is when the company doesn't actually have work available. They're typically a staffing company, and a staffing company means that when they hire you, they're going to place you at a client site for you to do the work there. But if they don't actually have the client lined up yet, they'll claim that we're going to put you on an in-house project and we'll find a client or a project for you later. Well, most of the time that in-house project is not real, or they've copied documents or a slide deck from some other project that is real and try to pass it off as their own. They definitely can check into all of those things as well. So when we have these fake projects and you're going for your visa stamping, there's definitely going to be looking into that fraud detection unit, FDNS, verifying. They look at the company's tax returns and they can easily see this company has not spent any money on developing this project. They've filed for 50 people saying all 50 people are going to work in-house on this project. And you Google their address and it's like a one-room office space, or sometimes it's not even an office space. It's a P.O. box, a UPS store or something like that. So it's easy to find out these things, and that is something that can cause a 221G and eventually denial of the visa.
H4 EAD, understanding of the H4 EAD. H4 EAD has a lot more freedom, guys. People can work as flipping a burger in McDonald's. They can be a Microsoft CEO. They can do business. They can get 1099. They can do possibly 99.9% of the things what a US citizen can do. And right now, when you file the H-1B extension, though, you can add the H4 plus EAD. Along with it, you will get the H-1B, H4, and EAD together. Even though you pay one filing fees, one premium processing fees, they will approve the H4 and EAD together. So that's a great advantage that we got it. Even if by any chance you miss out that opportunity where you did not get the H4 and EAD extended along with the H-1B, there are still other alternatives. You can file the H4 plus EAD extension while the H4 extension is still pending. Assuming that your current H-1B is not expired, you can go to Mexico, and when you come back, they will issue, you need to speak with a lawyer if you are not sure about how this process works, is that when you go to Mexico or to India and you are passport stamping until currently your passport stamping is not expired, you can definitely go to Mexico or India and come back. When you come back, you can request the H-1B based on your spouse's H-1B approval. So let's say, for example, your passport stamping is expiring in May of 2024, and you filed the H-1B, H-4, and EAD extension, and not along with the H-1B, but separately. H-1 got approved, H-4 and EAD got segregated somehow. You can go to Mexico or India. When you come back, though, don't just show the passport visa to come back. You need to show them your spouse's H-1B approval. Make sure that they give an I-94 for H-4 until the validity of your spouse H-1B. This is very common. We try to do this very many times. I've been successful almost 99% of the time. You can do this step because we have an automatic extension. If the EAD extension is pending for the H-4, you can work for a period of 180 days. So EAD plus extension receipt notice will allow you to work for 180 days. So these two steps are very crucial when you're extending the H-4 EAD, especially when you're doing a business, when you're working. You don't want any interruptions in the job or in your business. So you should make sure that your H-4 EAD extended properly. And there are no limitations for the H-4 EAD. You can work for multiple jobs. You can work for one job. You can do nothing and sit at the home. You can do any kinds of job. There is no geographical restriction where you can work at all on the H-4 EAD.
Yeah, and I'd also mention, I think a lot of people are not aware that when you're on H-4 EAD, you can be sponsored for the green card. So your employer can file a labor certification just like they would if you were on H-1B. They can file the I-140. And then once you have that, if you've had an H-1B previously and you switch to H-4 and H-4 EAD, you can always switch back to H-1B and continue even beyond the 6-year limit now that you have that approved I-140. So that's one option for people that are hitting that 6-year limit and they're waiting for their labor certification and I-140 to be approved. If they are married to an H-1B holder who has their own I-140, you can change status to H-4 EAD, continue the labor certification, continue the I-140. Once that gets approved, you can switch back to H-1B at any time in the future.
Anything else? Emily, when can they switch back? Can they switch back in 1 year, 2 years, over 10 years?
Yeah, anytime. There's no limit on that as long as they have the approved I-140 and the priority date is not current. They can switch back anytime in the future. If they're in the U.S., when they switch back, they have to show that they're maintaining their current status, whatever that is. But they can even exit the U.S. in 10 years from now, assuming the priority date's not current. They can have a new company file an H-1B petition that is not subject to the lottery, request consular processing, get it for 3 years because they have an approved I-140, get it approved, get the stamp, and come back, and you're back in H-1B status.
On this front, there is a question from Bhumika. She's asking that if I transfer from H-1B to H-4, will the H-1B time freezes? What she's asking is that, as people know, that H-1B has a limitation of 6 years. And if she moves to the H-4, will the clock stop for the H-1B or does it continue? The answer is the clock stops. Once you file the H-4 and you stop working, the clock stops. And you can get the H-1B back at a later date, whatever is the remaining period of time. You can get it at any point of time in your life. There is no limitation when you can get it. So the clock stops when you file the H-4 and stop working. Anything else, Emily, before we go to questions?
Nope, I think we can go on to questions. And this one is from Yahoo Me. They say they used the AOS EAD at the DMV to get their driver's license, and they want to know, does this change my status from H-1B to AOS? No, it does not change your status. So you're using it for something that's completely irrelevant to immigration. That's totally fine. It has no impact on your status. What does cause someone to switch from H-1B to AOS or EAD? Number one, it would be using the EAD to actually work. What it's for is to allow you to work. So if you're using that EAD to work, now you're in adjustment of status. Or if you stop working for the company that you have the H-1B approved with and you exceed the 60-day grace period, now you're out of your non-immigrant status and you are just relying on your adjustment of status. Or if you do anything to violate your H-1B status or whatever your non-immigrant status is. Those are the things that actually cause you to change from being a non-immigrant to being in adjustment of status and relying on that EAD.
Prem is asking this question from US Walks. I'm not against moving EB3, but if the EB3 goes down, doesn't all the people move from EB2 to EB3? Can they not travel in both lines? Yeah, they do. I don't know if you have ever traveled in Los Angeles. I hate the traffic in Los Angeles compared to any other city in the entire world. Maybe I haven't traveled to a lot many countries, but a lot many places. But in LA, the lane that I travel always doesn't move. And when I move to a different lane, that lane stops moving. So that's what happens with some of the people in the EB2 and EB3. Yes, people do switch from EB2 to EB3. If you look into the stats of the immigration, though, the amount of cases that were approved in the I-140 and EB2 that are waiting for the prior date to be current is way higher than that of the EB3. Yes, when the dates move, people do move, and that happens very frequently. From 2020 onwards, we have been, actually from 2018 onwards, we are seeing back and forth movement of EB2 and EB3 a lot more. So it's almost 6 years, and we will continue seeing that, especially for the Indian nationals.
Ravi says, if we don't process the I-140 from company A to company B, along with an H-1 transfer, what are the further complications? So when you are transferring from one company to the next, and you've had your I-140 with the first company approved for at least 180 days, you can use that I-140 to transfer your H-1B and get a 3-year extension. It does not require you to start the green card process with company B. And if your priority date is nowhere near being current, there's no need for you to immediately start your green card process over again with company B, because you might later move to company C or company D, and you don't need to keep redoing labor and I-140 every time you change companies, because your priority date's locked in and you can keep getting H-1Bs even with the old company's I-140 approval. Where does the complication come in is when you have transferred to the company and then you have not started the new labor and your priority date unexpectedly becomes current. That's what happened to a ton of people in October 2020. And so they were not able to file the adjustment of status when that window opened up, because they still had their labor certification in process with the company that they had recently joined. So you have to monitor the visa bulletin, make sure you're aware of when your date might become current so that you give yourself 2 years in advance to get the labor and I-140 approved based on current processing times.
Emily, what if I want to move from company B to company C? Does I need an I-140 approval from company B, even though I got an I-140 with company A?
No, you can keep using company A's I-140 approval to move to company B, C, D, E, F, all the way down the line, as long as your priority date is not current. Puneet says, I'm getting a promotion from a technical role to a technical manager role. Does the green card need to be restarted? My perm is in process with DOL. So part of it depends on the attorney and how they are advising the company. But our stance on this is most of the time it does not require the process to start over again. USCIS does recognize that jobs change over time. You'll be promoted over time. They definitely recognize it in the AC-21 job portability reference when you have a pending 485. Now, of course, you don't have a pending 485 yet, but in 20 years, I've never had a problem with USCIS coming back and saying, hey, you've been promoted since you filed your labor certification 10 years ago. We're not going to approve your 485. That's never happened in any of my cases.
A question from Ashwin. His 3 years H-1B, initial 3 years H-1B is expiring in September of 2024. He is actually moving from company A to company B. Can he request a H-1B from March 2024 to all the way to September 2027, which is 3 years and some 4 or 5 months more than that? No. You cannot request H-1B for more than 3 years. You can only request up to 3 years, but not more than 3 years. Srikant has a question. His kids have received the passports, and there is a signature part of it which says that it's valid only when you sign. The kids can't sign. They're very young. What do we do? You can sign for the kids. So that's perfectly all right. You can just say that dad signing for a son or a daughter, and then you can sign on behalf of them. Absolutely, that's not going to cause any problem, none whatsoever at all, at a future date.
Sai says, if I change from H-1B to H4 EAD, can I always go back and use my leftover H-1B period when needed? Yes, absolutely. There's no time restriction on that. You can do it as long as you have recapture time available. That's time left over towards your 6-year limit. And you, even if it's been more than 6 years, even if you're no longer with that company, you don't have to go through the lottery. It can be filed at any time, and you can request the remainder of the 6 years that you have left.
Kiran has this question. Under the cross-country chargeability, do we need to file separately for spouse and the principal applicant if they are from USA? The answer is no. You have to file it together. You can't file it separately, though. Otherwise, they won't accept your 485 application. If your spouse, assuming that you are the principal applicant and your spouse is filing by herself, they won't accept it because I-140 doesn't belong to her. If you file by yourself, they will say that you are not filing with your spouse because you're not eligible for the cross-country chargeability. I want to explain what a cross-country chargeability is for those people. Let's say, for example, you are born in India and you're an Indian citizen. Of course, you all know that the priority date backlog is very significant for you. Let's assume that you marry somebody from Pakistan. You know that the priority date is very fast. Even though you are the main applicant, that is the Indian is the main applicant, even the spouse is a dependent, you can use the spouse's country of birth to file the 485 application based on her country of birth, which is Pakistan. That's way then you can cut the timing period though. Emily, I have one question from Pratim that I want attention of you. What do we offer solution for the people from Apex IT Solution, which we have published a YouTube video about a month ago, approximately around 500 to 600 people were being issued employment letter. Some of those people were being issued a 983. They are operating from India. They took the money, and USCIS now finds out that this is a fraudulent company. And all these people, approximately about 500 to 1,000 people, have reported the company that they are working as Apex IT into the civic system and informed the DSO and updated the civic system. What are we advising them right now? What are we advising if they are an OPT? What are we advising if they're STEM extension right now? What are we advising if they're an H-1B?
Yeah, I mean, it could definitely come back at any time. When you're on OPT and filing the STEM extension, they do look through all of the SEVIS records, not just the current I-20 that you submit. And even on that current I-20, it shows all of your employment history. So they are going to see that you have previously worked for one of those companies, and they could potentially deny the STEM extension on the grounds that you violated your F1 status and worked and did not and were basically unemployed during that time because they know that they didn't provide actual employment. Same thing when you file a change of status to H-1B, they could argue that F1 status was not properly maintained, they can approve the petition but deny the change of status. That means it comes without an I-94. You have to exit the country and apply for visa stamping. So, you know, when something like that happens and you need to apply for the visa stamp, you have to be truthful when you're filling out the DS-160 and be prepared to submit a waiver of that ground of inadmissibility for getting whatever non-immigrant visa you're applying for at that time. Yeah, it's definitely a tough situation. I don't think there's anything you can do proactively unless you're in the situation where you were actually taken advantage of by this company and did not know and thought everything was legitimate. Then you can try to gather as much documentation as you have to prove that. Otherwise, probably don't travel and just keep your fingers crossed when filing anything with USCIS.
I just want to tell the people who are not from Apex IT Solutions, what exactly is the issue of this Apex IT Solutions is that the fraudulent companies have taken money to issue the OPT letters. None of the people who are working with Apex IT Solutions have ever visited the company because it's a PO box. You can't visit a PO box there. None of these people have ever met any individual in the United States. The reason is that they're operating from India, though. All they relied upon is a website and the e-verification. Hey, the company is e-verified, so I'm good to go. Not true. You need to know about the company, especially when you are getting training from the OPT or STEM extension. You need to know about this company. Now, we believe that, at least I believe that there was a company called Integrand Aztec Solution that got into trouble, but they were operating from Calcutta, though. Approximately about 4,600 people got affected with these companies, Anvil, Aztec, and Integra Solutions. The money was taken by a company called Wireclass. They opened a company from India. They operated from a company from India. 4,600 people have got the OPT letters from these companies. Some of them got the STEM extension 983 signed by these companies, and they submitted to the DSO and updated the service system. So that is considered fraudulent when you're paying money to obtain an immigration benefit for the OPT employment letter, though. You're not supposed to pay any money. So these, and if there is any employment discrepancies, though, you're supposed to report it to the DSO within 10 days. And these people, most of the people have taken much longer. Some of them have years. They've been on the particular company called Integra and other companies that we are speaking about. We want you to be very cautious, though, that you avoid these kind of schemes. Even right now, people are wanting to file a H-1B with multiple companies. I don't know what crazy thing that they're thinking. Previously, we told not to do it, and you know how the shock happened. And now we are still telling, remember that it's not just that you're not getting an advantage right now, but you're associating, you're collaborating, you're conspiring to commit fraud on the immigration by filing a H-1B with a company which does not have a job for you. That's very important for you, that which does not have a job for you. So please don't get into these things. This is a long-term solution. If you have, don't try to cut down and do any illegal activities. So if the job has to be genuine, whether it's an OPT or STEM extension. Emily, some of these people, they got some voluntary jobs, but is voluntary job allowed on OPT, Emily?
Yeah, absolutely. The OPT does allow part-time employment. It allows unpaid employment as long as it's complying with the Labor Department minimum wage requirements and for internship rules. There's special rules on that, but yeah, it can be unpaid. So if you're in that situation where you're reaching your unemployment limit, don't go to one of these fake companies and think that that's your only option. There are a lot of other options. You can volunteer doing anything that's similar to your education background. You can start your own company as long as it's related to your degree. Go back to your school, ask a professor, hey, is there any research I can help you with for the next few months part-time for free while I continue looking for my job? There's plenty of other options that you have to avoid exceeding that unemployment limit. Now, once you're in the STEM extension, then the rules are a little bit different. It does have to be paid employment, and it has to be at least 20 hours per week. But we see most people using these companies in the initial 1 year of OPT to avoid exceeding the unemployment limit.
Aman Seti has this question. Can I change, if H-1B is picked up this year, can I change the rules before October and file the H-1B? I mean, I don't know what he meant by file the H-1B. Now, this is what I would suggest though. At the time of filing the H-1B lottery, you don't have to specify any role. You have, once you get selected in the lottery, which will happen somewhere between March 22nd to about April 1st week, that's about the time that you will get your lottery result. You have until June 30th to file the H-1B. If you're anticipating that there will be a role change, what I would suggest you to do is file the H-1B in premium processing, not in the regular processing. The reason is that if you file in a regular processing and then later on the RFE comes in, the role doesn't exist and you already crossed October, that will become, if a denial will be fatal for you though. So what I would do is that I will file a H-1B in premium processing, get it approved for the current role. And if there is any modification, you can always file an amendment on October 1st. That is the best strategy if you are anticipating any changes in your job.
Dora Babu says, can
one minute. This is only if you are moving within the company to a different role. If you're planning to change the company, that's a completely different rules are there. Go ahead, Amy, sorry.
Dora Babu says, can I change location during the STEM EAD application that's pending with USCIS? So if you mean move from one house to another or one apartment to another, yes, you can. There's no problem with that, except that you need to be very diligent with USCIS to make sure that they have your new address so that when they actually approve the card, they mail it to the correct address. We see many times when people change their address, they don't notify USCIS, the card gets sent to the old address, disappears, never gets sent back to USCIS, and then you're out of luck. You just have to refile for the lost EAD card, which can take many more months. And in the meantime, you're stuck with no proof of status that you can provide to your employer for the I-9 purpose. So if you can avoid it, or if you have someone that can get your mail at the old location, yes, it can be done, but it can cause issues with where they send the card.
Question from Aninda. She is working on H-1B right now. She has an advanced parole based on the adjustment of status on the employment base. Can she travel on advanced parole? And once she comes back, can she continue working on H-1B without any problem? Absolutely, you can do it. Once you come back on advanced parole, your H-1B is still valid. You can continue working on the H-1B. You can extend it. You can amend it. You can transfer the H-1B. Not a problem, Aninda. Continuing question on APEX system, I would strongly recommend anybody affected by the APEX system contact an immigration lawyer immediately. It's not that you may, the immigration lawyers may not have an immediate solution, but at least you will get an idea what may happen, when the thing may happen. Especially Mr. Pratim is asking a question about his wife, especially traveling outside the country and coming back. Definitely you're exposing your wife to the CBP. They may deny her entry into the United States.
Chandrakant says, is there any way we can just have one I-140 petition for a lifetime instead of a single one for each employer or each job change? Because any new perm in I-140 is taking 3 years for approval. I mean, in some respects, that is possible because, as I mentioned earlier, just because you've changed employers, if your date is nowhere near being current and you're able to use employer A's I-140 to keep getting H-1B extensions with any company, it's not necessary for you to do labor and I-140 with every single company you switch to. You just have to make sure that by the time your priority date is current for you to file the 485, you then have one more labor and I-140 approved from the new company. And same thing for job changes, promotions. If it's within the normal career progression and you're still doing the same work and you're still working in the same location, it may not necessarily be needed to do a new labor certification every time something like that happens. So yes, it is annoying that you have to keep doing these in order to actually get the green card, but the only way to change that is Congress, and we know they're not doing anything.
Can you give me an update with modernizing H-1B policy about H-1B employees opening a startup companies or registering LLC as part of the new policy? Raghavendra, yes, that is in the pipeline right now, but it's not yet published and become a regulation yet. We're expecting it in the coming months. I can't tell you the exact time when it's going to be, but maybe by the end of this year, that may be coming up.
Kishore says, does the H4 EAD need to be applied if the H-1B holder changes employers? No, it's not necessary. The H4 EAD and the H4 remain valid as long as you are maintaining your H-1B status, whether it's with your current employer or the new employer. You may want to consider applying for the H4 and H4 EAD anyways when you're changing employer. Number one, so that you all have the same end date, because sometimes people forget that the H4 expires before the H-1B and the H4 falls out of status because of that. But also because when you file the H4 and H4 EAD with the H-1B, they will approve all of them together and you can get that premium processing time frame, so you're not stuck with the possibility of the H4 EAD expiring while you're waiting to do a standalone H4 EAD renewal.
MB has a very question. Last time she got into the lottery, but the company didn't file the H-1B in proper timing. As you know that if you don't file in the proper timing, you can't file it. Her question is, can she file the H-1B with the same company in the lottery again? Yes, you can. Just because last time you got selected and didn't file it will not have any negative effect. Hopefully, MB, this time they're going to file your H-1B.
Siddharth says, how long is an AP renewal taking? I filed in the Texas Service Center at the end of August 2023. They are taking a year or more right now. Most of the approvals that we've gotten in this week and last week were filed in February 2023. So they are taking a very long time.
Vagabond Daisy has filed a 485 application or adjustment of status based on the EB5. Can I start working on approved 765, or do I wait for the EAD card? Well, the difference between the 765 and EAD card should be less than a week though. So you can wait for like 1 week time and get an EAD card and start working on it. Well, one thing that we want is that if the I-526 is not approved, we may not recommend you to start working on the EAD though. Because if the I-526 gets denied, though, then the entire EB5 application will fall down, and then you might have to run outside the country to see what to do. So I would definitely recommend that wait until the I-526 is approved.
P. Verma says, I currently have my I-140 approved, but my H-1 is cap exempt. If I decide to leave the U.S. and come back when my priority date is current for a different job, can I only work for a cap exempt company then? Yes, that is correct, because you've not actually gone through the lottery. You've not been counted in the cap. You can only work for cap exempt H-1B employers. And also, you can't wait until your priority date is already current to get that H-1B, because at that point, you're not going to get a 3-year H-1B. You only get a 1-year H-1B, and that becomes much more difficult for the new employer to file the labor certification and I-140 to allow you to file the 485. So that's the other thing to consider. If you are exiting the U.S. and planning to come back in the future based on the fact that you have an approved I-140, you need to have that H-1B filed before your priority date becomes current so that you can get a 3-year H-1B.
Zorif is asking, is there any way that I can figure it out that if my previous company is flagged, the company's name is H4 Solutions, we can't just tell that based on that, but I would say that if anybody, these are the common things for flagging. If the company has filed multiple H-1B, if you have filed multiple H-1B applications, that is a red flag. If you have filed a H-1B with an internal project, which we know that is not, I'm not speaking of Apple, Microsoft filing internal project, but a consulting company, as Emily explained, with 50 employees internal project, and it's in a PO box. Definitely, that's a red flag. It may affect you in the long run, though. We do see a lot of H-1B revocations. And even, let's say, for example, if you work with company A in an internal project, which we know some of those things, and later on you moved on to company B or company C, if the company A got you the first H-1B approval, the USCIS may revoke the company B's H-1B approval or company B's H-1B transfer, saying that since you're not counted properly on the H-1B, though, your subsequent H-1Bs are depending on that lottery. That's why you're not eligible for the transfer. That may become a serious problem at a later date.
Manoj says, if I have an approved I-140 for more than a few years, is it mandatory to file a new I-140 with an H-1B transfer, or the I-140 only comes in the picture when I file for the green card? So you can keep using the old I-140 to get H-1B renewals with any company as long as your priority date is not current. Once your date becomes current, that's when you have to have the new labor and I-140 in place to be able to actually file for the green card.
I have a dependent GCEAD. Is it advisable to file an H-1B as my spouse's company is laying off people, EB1C, L1A, and his job is at risk? First thing, yeah, you can file the H-1B. It is advisable. But one thing is that if your spouse has already filed the 485 application, and if your spouse is about to lose the job, though, there are a lot of alternative solutions. You can move to a different job. You can employ your spouse and have him work on the EAD, because you have an EAD, most probably your spouse has an EAD too, or he can self-employ himself to keep the 485 alive. What I'm more interested in is keeping the 485 alive, not giving up, though. Emily, we may want to do a separate video just on AOS losing the job, Emily. We'll try to do it this week.
Yeah. Parikh says, I have a H4 visa stamp, which expires June 30th. I have the H4 extension already approved and I have to go to India. Can I come back on the old visa stamp and show the new H4 approval at the port of entry to the visa officer? Yes, you will want to do that so that you can get the I-94 to the full time of your H4 approval. However, if you're coming in super early, way before July 1st, when your new H4 kicks in, sometimes they won't give you that extended I-94 and they'll only give you the I-94 until June 30th. So just be careful of that. If you're like going and coming back in March, it might not work. It depends on the officer at the port of entry. We're seeing lots of inconsistency there. Deepak says, nowadays they're just updating the I-94 online and no stamp on the parent's passport. Please advise, is this correct? Yeah, when you travel, they don't physically stamp your passport anymore. It's just updated online on the CBP website. So every time they enter into the US, they need to go to that website and print out the I-94, check it, make sure it's correct, make sure the date of entry is correct, make sure what end date they give. Did they give you 6 months or did they, for some reason, only give them 3 months? You need to know that end date so they don't accidentally overstay. But every time you come into the US, check the CBP website for the I-94.
Arnav has applied for the kid 14-year age out new green card application, which is I-90 online, which is an online process, and you go and get the fingerprints done, which is not a very tough green card process, though. During the process, can we travel outside the United States? You can have an InfoPass appointment, have your child's passport stamped with the temporary green card, which they will give it, and based on that, you can travel. It's a simple process. You don't need any lawyer or anything like that. It's go to InfoPass, and you can make an appointment and get the kid's passport stamped.
Nargajana says, if someone's laid off, how soon do you suggest to apply for a compelling circumstances EAD to protect their legal status? Well, It depends on whether you have the 60-day grace period, and if so, when is your I-94 expiring? If it's expiring before the end of the 60-day grace period, then you really don't have a 60-day grace period. You only have the time till the I-94 expires. But for a lot of people, they have many better options than the compelling circumstances EAD. You have the 60-day grace period. A lot of people have the option to switch to H4 and get an H4 EAD through their spouse and then switch back to H-1B in the future. You have the option to change status to B2 and then change status back to H-1B without leaving the country. With the compelling circumstances EAD, it may take 8 or 9 months for you to get that EAD, and so you can't work while you're waiting for it. And then in order to get back into non-immigrant status, you're going to have to exit the country. There's no change of status from compelling circumstance EAD back to an H-1B. So it has to be consular processing. You have to go for visa stamping and then come back. So compelling circumstances EAD, yes, it's an option, but sometimes it's the last option on the list.
I learned from R-in-law. That's nice. If I upgrade the H-1B extension premium processing, will it facilitate the H-4 approval also? Assuming that you have filed H-1B and H-4 together, it will facilitate the H-4 approval too. Even though initially you have not filed in premium processing and now you're upgrading, you can still get the H-1B and H-4 approved at the same time.
The Explorer says, my spouse is at a director level, having 100 people reporting in his team, and his boss is on the C level. What are the chances for us to apply in EB1? Well, it doesn't matter so much. Well, it does matter what your current job is, but in order to qualify for EB1C based on having a manager or executive level position, you had to have worked for the company abroad for at least 1 year in a manager executive level position. So if the company doesn't have any locations abroad, or you never worked for them abroad, even though he's a director level now, it still won't qualify. It's all based on the qualifying relationship between a company outside the US and a company in the US, and you having worked for that company outside the US for at least 1 year in a managerial or executive capacity.
Ajinkya Joshi has this question. I think so. I consider this question as the question of the day. Very good question. This person got laid off. Within the 60-day grace period, do we have to just file the H-1B application, or do we have to get the H-1B approved? The first answer has some conditions. You have to not only file the H-1B, but you must also start working within 60 days. So it's not that you file within 60 days. Now, the second part of the answer is, do you need to get the approval within 60 days? No, you don't need to get the approval within 60 days. You only need to file. But there is one other condition. Not only you need to file, but you also should start working. What if you file a H-1B application and you don't start working for the company for the next 6 months? Is that allowed? No, then you'll be violating the status. You not only must file, but start working within 60 days.
Abhijit says, my friend was in the US 20 years ago, was on H1 for only 2 years, and then moved back to India. If he wants to come back to the US now with the same company, can he use the previous H1, or does he need a new H1? Well, his H1 expired because it's more than 20 years, so he needs a new H1B, but he's not subject to the lottery because he has that recapture time and he's already been counted. So whether it's the same company or even a different company, they can file an H-1B any time of year, does not have to go through the lottery. Once it's approved, he applies for the visa stamp at the consulate and then comes back into the US to continue the remaining 4 years.
Birendra has this question from Twitter. Well, it's called X right now. Keep calling the same old name. Can H-1B holder have a driving license in a different state than resident state? Does it create an issue? Yes, it may create an issue, especially when you file an extension of the H-1B, when you file an amendment of the H-1B, they may notice that your driving license is from a different state. So let's say, for example, your H-1B says that you are working in Florida, and then you have a driving license in Texas, though. They may see that, they may consider that you're not actually working in Florida, you're actually working in Texas, but you're just showing the Florida. So I would request it's better that you correct the driving license so that you don't give any wrong impression to the government.
Pranav says, is litigation an option for processing delays by USCIS for an advanced parole application? Yes, absolutely. We do file those for interim benefits that are delayed by USCIS. Stephen Brown in our office handles those cases, so you can reach out to him. His email is steven@rnlawgroup.com.
Govinda Sankura has this question: is a birth certificate mandatory for green card? Yes and no. There are alternatives. If you don't have a birth certificate, though, you can get a non-availability certificate. What does that mean is that you can get a letter from the Indian authorities saying that your birth certificate is not available. And then you can supplement it with two affidavits from your parents or any family members that can say that you're born to so-and-so mother and father and the date of birth. So it's a non-availability certificate plus two affidavits. And sometimes we may even supplement with Aadhaar card, PAN card, ration card, election card, and a lot of different government-issued IDs are there in India. We can supplement it. But one thing is non-availability and the two affidavits are a must.
Anunda says, I'm on H-1B with no visa stamp and my AOS is pending. Can I travel and re-enter using advanced parole and continue working on H-1B for the same employer? Yes, absolutely. That's exactly what the advanced parole is for. So as long as you have it when you leave and you come back on that advanced parole, then you go back to work for the same employer and the same job under the same terms and conditions that are mentioned in your H-1B petition that's approved. You are in H-1B status and can continue extending your H-1B as if you traveled on an H-1B visa.
Somit Saha has this question: are there any update on extending the pilot phase of the visa stamping in US though? We do get some updates that, yeah, passport stampings have already occurred within the United States. I'm pretty positive that this pilot program will be extended though. However, I would recommend that, we have no information at this point of time when that will happen, but I'm pretty sure it will happen. Do you have any doubt, Emily, that the pilot program will be extended?
Yeah, I don't see any reason why they would not extend it and expand it. Ravi says, can we work at an LLC startup that's a non-E-Verify company as an unpaid intern during my first year of OPT? It depends. Is the work that you're doing directly related to your field of study from the school that you graduated with and got the OPT for? If yes, then yeah, absolutely. No problem with that at all.
When I'm on the GC EAD AP visa status, people are asking whether I'm on the citizen, GC, or a visa. Well, normally though, they will ask you the question, do you need any sponsorship? Especially if you're in GC EAD, you can answer, no, you don't need any sponsorship. But if they particularly ask you, what is the status of you? You may have to respond to them as EAD, or if the adjustment of status is allowed, you can put that status too.
MK says, my EB-2485 was denied in error, saying that we applied when the dates were not current. We created an ombudsman service request and the status is updated saying the case is reopened for reconsideration, but it's been like that for 6 months. Does this mean the case is reopened or are they still reviewing whether to reopen or not? You should reach out to the ombudsman and ask them to clarify what exactly that means. Now, normally when we have this situation, we would file a motion to reopen or reconsider on an I-290B, and we actually get a decision telling us we agree and we are reopening your case, and then it's reopened from that point. With the ombudsman, you may have to follow up with them to find out whether they're still reviewing or if they've actually reopened it and the case is pending.
Emily, that's a dangerous process the gentleman did, only going with ombudsman without filing a formal motion to reconsider. Is that right, Emily?
Yeah, I would usually file the motion to reopen, reconsider, and then go to the ombudsman for assistance, because Yeah, you have to file that motion in order for your status to continue in adjustment of status. Once the case is reopened, it's as if the denial never happened. But if the ombudsman decides not to help or they can't, you've missed your chance. You only have 30 days to file that MTR. So you've kind of left yourself with no other options by only going the ombudsman route.
Pratim has this question: would Reddy Neumann be able to help with the Apex system situation? Pratim, we are not, we don't have any magic wand that, okay, here do 1, 2, abracadabra, everything disappears. We don't have it. At least Reddy Neumann PC doesn't have it. We are not going to speak about the other law firms that may have the magic wand. We don't. We can give you the realistic pictures, realistic solution. But if you come to us, can we just have a magic wand and disappear the things? No, we don't have it. My parents' I-130 is approved. My question, are they legally allowed to travel to USA from India? We do not advise them to travel to India after the I-130 is approved. We recommend that they stay there, get the green card, and come back into the United States. Vikas Wade has this question. My fiancé lives in California. I'm from India, applied for K-1 visa, but the US Embassy stopped our marriage and ruined everything. Please tell me, how do I get my love? We're noticing a lot of problems on K-1 visa, though. What we're suggesting people is, instead of K-1, which the processing is a nightmare right now, get married and file an I-130 application, though. That's going to be a stronger case rather than filing a K-1 visa. K-1s are taking forever. And we see a lot of problems in K-1. We are just telling people, get married. If you're going to get married in USA, why not get married wherever you are? That will solve the problem for us, for you, and for everybody. But yes, it may still take for you 2 years to get back into this country, though. You probably wasted all this time waiting for the K-1 to be approved.
Lokesh says, I'm going for H-1B stamping. I have a client letter, vendor letter, an employer letter, all three of them listing my roles and responsibilities. Can I use the client letter as my employment verification letter? No, you don't work for the client. You work for your employer. You need an employment verification letter from your employer. So definitely be careful of that, and just be very careful in your interview to make sure you understand who your actual employer is. It's not the client. They are the end client, and you are working for your employer. So make sure your LinkedIn doesn't show you working for the end client as your actual employer. Definitely be careful before you go for stamping to make sure you understand the terminology. Otherwise, you can end up with a 221G.
My friend lost a job 70 days back. He applied H-1B to B-1, B-2 on 55th day. Sounds good, perfect. Today he got a full-time job, but the company is saying that it's risky to file the H-1B. What to do with the situation? Absolutely, it's not risky. We have filed so many times. Thousands of people got the H-1B approval. I don't know where these lawyers are looking at. Tell them to come to the Reddy Neumann PC YouTube show so they can learn immigration. Looks like you know better than that immigration lawyer.
Yeah, I mean, it's on their website. It's so clear.
Well, but they don't go to the website and they don't come and visit our YouTube.
Yeah.
So,
and they probably haven't filed an H-1B transfer in the last 2 years.
Anything else, Emily?
Well, looks like it's time up for today. Thanks everyone for joining us. Don't forget that we do have a daily conference call where we answer your questions live. You can get the details for that by going to rnlawgroup.com. And don't forget to subscribe to our YouTube channel if you're watching us there, so you'll get updated whenever we do have new videos and go live. And thank you for joining us on Twitter and Facebook as well. Be sure to follow us on our Facebook and Twitter page so you can stay up to date with all the latest.